we've read the brief that you submitted, and we're ready to hear your oral argument. And you will have 15 minutes, and there's a clock on the wall, and I'm also keeping track of the clock.
I'm not looking at the clock.
Okay, I'm keeping track of it, so
I don't have all them codes, so please understand that.
Okay, okay. So we're ready to go ahead and hear your oral argument today.
If it'll please the court, I'm Sheila Crosland, and I am representing myself. On September 19th of 2022, owner landlord, Mr. Tucker, he posted a 30-day notice to the door of 38 Euclid Street, Marshallville. He did, which expired October 31st, 2022. He did not follow through with a 3-day posting. He let that go. He got filed, put that on a door, or filed with the court. And then December 27th, Mr. Hanzie, he posted a 30-day notice on our door and for us to leave the premises. Then he signed it as a landlord, which he is not our landlord. It expired January 31st, 2023, and he also signed that as a landlord. Then he posted February 3rd, 2023, Mr. Hanzie did. He posted a 3-day notice to leave the door of 38 Euclid Street, which Mr. Tucker owns. Then on Wednesday, February 8th, 2023, Mr. Hanzie filed a 3-day eviction notice with the trial court, which was too early because you're not supposed to count weekends and holidays according to the law, Ohio law, and which he should have filed on February 9th, 2023, and he also signed as a landlord on that. And according to the Wayne County Fair Housing booklet, law booklet, page 6, under tenants' rights and remedies, it states if the landlord fails to provide the tenant with a written statement of the names and addresses of the owner and agent when the tenant moved in, the landlord waives notice under the states. Waives notice are under to give written notice. Ohio bar states you have the right to know the names and addresses of the owner of your residential premises and the owner's agent if applicable. This information must appear in your written lease or be given to you in writing when you begin your tenancy. Mr. Hanzie would fall under the category of Mr. Tucker's agent. We were never informed of Mr. Hanzie that he was Mr. Tucker's agent when we moved in. According to MizukoLaw.com eviction law, the basic rule when calculating the 3-day notice of an eviction, the basic rule in Ohio is the day of posting. Weekends and holidays don't count when calculating the 3 days of an Ohio eviction notice. Ohio landlord tenant comp. Number 2, how do I calculate the 3-day notice to vacate expires? The day of posting, weekends, and illegal holidays don't count when the 3rd day notice expires. Or 3-day, sorry. On Friday, February 3rd, 2023, when Mr. Hanzie posted a 3-day notice to leave the premises to the door of 38 Euclid Street, 38 Euclid Street, February, and on Wednesday, February 8th, he filed with the trial court. The trial court should have dismissed the case based on early filing according to Mizuko law, and the trial court didn't have the right to the jurisdiction or authority to rule upon the eviction. On March 2nd, the Crosland showed up at the trial court and requested a continuance postponement to obtain legal counsel, but were denied the continuance postponement by Judge Shaker. By Judge Shaker denying continuance postponement, I feel that our 14th Amendment right was violated because it took our equal protection of laws away, and the opposing side had legal counsel in the form of Attorney Groa. And we were made to represent ourselves under duress. According to the Wayne County Fair Housing Law Booklet, page 8, eviction states if the tenants or their attorney show up and raise questions about the landlord's right to evict them, the judge will postpone the trial for up to 8 days or more. The Crosland showed up to the eviction hearing and raised questions about Mr. Hanzie's right to evict them, because Mr. Hanzie was never our landlord or property manager in the 15 years we lived there. Mr. Tucker was the owner, landlord. On 3rd, 26th of 23, we, the Croslands, filed a motion to immediately vacate and dismiss the eviction judgment. We tried to point out the motion that the 3-day in the motion that the 3-day notice was filed with the trial court too early, and the eviction should have been dismissed. But Judge Rickett denied the motion, and we feel that we were, for the foregoing reasons, we feel that we were illegally evicted by somebody that was never in the picture as an agent. Didn't own the house or anything. And we asked that this court sides with us or whatever, that they be punished, the opposing side, because they made fun of my disabled daughter at the eviction judgment. And we asked the court to remove the evictions off of our records, and for the opposing side be punished for the wrongful and unlawful eviction judgment, for the denial judgment of our motion for vacate and dismiss the case, as well as the misconduct that took place in the courtroom when Mr. Hanzie, attorney Mr. Groa, and Judge Mr. Shaker laughed and made fun of my disabled daughter.
Ms. Crosland, could I ask you a question?
Yes, ma'am, you may.
My understanding is that you have left the premises.
Yes, I have left the premises because they cited for them to, for the eviction,
Right.
which I felt was unfair.
So what are you asking the court to do today?
I'm asking the court to take away my court costs, because they got like $125 court costs for us, and I'm asking the court here today to take away our judgments on our records of the eviction.
So you're not asking to be reinstated, you're asking for your record to be cleared and your court costs to be refunded?
I didn't pay court costs, it's still on the court website.
For that to be vacated?
But I want if any costs, and if they try to, they haven't tried to sue for attorney fees or anything like that yet, so I don't know if that's coming, but we'll cross that bridge when we come to that. And any other questions for us? For your honors, I'm sorry.
It's okay, you're doing a great job.
Nervous, but, so, that's all I have to say today.
Okay, thank you. Thank you for coming to court today, for presenting oral argument. The court will take the matter under advisement. We'll discuss the case together. We'll issue a written decision. That written decision will be mailed to all parties to this appeal. So it's important that your current address be listed in the court records. But it also will be posted on the Ohio Supreme Court website, and it can be found there as well. thank you again. The court is adjourned until